Good morning. My name is Christian Lada, CPA, President of the California Board of Accountancy. We'll go ahead and begin our meeting today on January 23rd. Welcome on this Friday morning. We'll go ahead and turn this over to Ms. Reed to establish a quorum.
Member Aguilera?
Present.
Member Batchelor?
Here.
Member Corrigan?
Corrigan, present.
Member Dong?
Present.
Member Hines?
Present.
Member Lada?
Present.
Member Lynn? Member Rafel?
Here.
Member Thompson?
Present.
Member Two?
Here.
And Member Zielinski?
Present.
We have a quorum.
Thank you. I will now read our mission statement into the record. The CBA's mission is to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with established professional standards. This mission is derived from the statutory requirement that protection of the public shall be the highest priority for the California Board of Accountancy in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with the other interests sought to be promoted, the protection of the public shall be paramount. At this time, I will turn it over to the Honorable Matthew Block, who will oversee the petition hearings. Please proceed, Judge.
Thank you. Good morning, everyone. We have two petition hearings on this morning. I believe we'll take up the Barton petition first. Ready, Mr. Bernard? All right. We're on record before the California Board of Accountancy in the matter of the petition for reinstatement of a restricted area of practice of Gregory D. Barton. This is board case number AC 202036, Office of Administrative Hearings, case number 2025-110-263. May I have our court reporter please state his name and CSR number for the record?
Good morning. My name is Emmett Barnard. I'll be the court reporter today, and my license.
Thank you. May I have the appearance of the Deputy Attorney General?
Deputy Attorney General Ted Durkar.
And may I have the appearance of the attorney for respondent or petitioner?
And Mr. McCauley, you'll need to unmute yourself.
Apologize. Good morning, Your Honor. Noel McCauley on behalf of the petitioner, Greg Barton.
Morning, and Mr. Barton is present via video, correct?
That is correct. Thank you.
All right, good morning to you, sir. We established before going on record in this matter that a quorum of the board is present. What I would do now is just call a brief roll call, ask that the members respond when their name is called. Ms. Dong?
Present.
Mr. Lynn? Yeah. Ms. Lada?
Present.
Mr. Aguilera?
Present.
Ms. Batchelor?
Here.
Mr. Rafel?
Here.
Ms. Tu?
Here.
Ms. Corrigan?
Present.
Ms. Zielinski?
Present.
Ms. Thompson?
Here.
And Ms. Hines?
Present.
All right. As I said, a quorum of the board is present. The manner in which we'll proceed this morning is I will turn first to Mr. Durkar to present the petition, provide an overview of the case. I'll then turn to Mr. McCauley and his client if they wish to make an evidentiary presentation. At the conclusion of their presentation, they will be, or Mr. Barton will be subject to questioning by Mr. Durkar and the members of the board. With that, Mr. Durkar, I will turn to you.
Thank you, Your Honor. I appear on behalf of the people of the state of California by authority of Business and Professions Code Section 5115 and Government Code Section 11522 for this hearing on the petition for reinstatement of a restricted area of practice by Gregory Douglas Barton. Mr. Barton is appearing remotely via video conference along with his counsel, Mr. McCauley. My role here is to assist Your Honor and the board members in fact-finding. This role is not adversarial, but is intended to protect the public health, safety, and welfare I'm here to ensure that you have all the information that you need to make a reasoned decision. Turning to the evidence before us, the board members and petitioner have been provided with a copy of the same petition packet, which totals 97 pages and has been date stamped with GDB-PE2, PET, and then a page number. Your packet includes the notice of hearing at page 96 and petitioner's response at page 94, stating that he'll appear virtually, which he is here via video conference. The petition and its supporting documents span pages 4 to 64 of your packet. I'd like to mark the whole 97-page packet as Exhibit 1, and I offer it into evidence.
Any objection, Mr. McCauley?
None whatsoever. Thank you, Your Honor.
All right, Exhibit 1 is admitted.
Your Honor, I'd now like to provide a summary of the case.
Please.
Mr. Barton received his CPA certificate in 1985. His license was disciplined by this board in 2021, including a 3-year probation and a permanent practice restriction that prohibits him from serving as a trustee or being appointed as a trustee by a probate court. The accusation against Mr. Barton was filed in 2020 against him and his accounting firm, Barton CPA, which is a corporation. The accusation sought discipline based upon a misconduct as a trustee in administration of a trust, and that misconduct included repeated acts of negligence, breach of fiduciary duty, failure to comply with professional standards. The underlying facts are that he failed to report to the beneficiaries of the trust as he should have. He failed to timely distribute funds, and he put a property at risk of a tax lien sale by not making property tax payments. And he didn't keep up with trust accounting as he should have. Finally, he also made tax reporting errors resulting in overpayment of taxes by the trust. And he signed tax returns prepared by by employees of his firm, which he didn't review for correctness. Mr. Barton and his firm stipulated to the disciplinary order that this board adopted, and probation ran from August 2021 until August 2024. The restricted practice is still in place, and that's what he's here about today. He'd like this board to end that restricted practice order so that he has an unrestricted license. In the attachment to his petition, Mr. Barton explained in writing why he believes the petition should be granted. He claims that he's demonstrated rehabilitation, professional growth, and improved his commitment to ethical standards. He says he's been transparent with his clients and the staff at his firm about his practice restriction and the fact of his discipline. He claims that right after the disciplinary order was issued by this board, that he met with his firm's executive team and created rapid turnaround milestones for the firm, but he doesn't get into what those were. He also reports that his firm has executive team meetings on a weekly basis to review and implement new procedures and protocols as warranted, but none of those are described either. He says he now holds annual firm retreats, and he claims the firm has improved internal controls and training. Finally, he reports that he appointed his firm administrator to become a chief operating officer as part of the reforms at the firm. Mr. Barton reports that if his petition is granted, he doesn't plan to provide trustee services to his clients. Instead, he'll continue to do tax preparation, tax planning, accounting, consulting services, and he'll continue managing his firm. That's what he'll devote his time to. He says he wants the removal of the trustee restriction because it will allow him to present the firm fully and without limitation, and thereby attract more clients. He feels like the restriction is holding him back from developing the firm's clientele to its potential. Mr. Barton submitted documentation of 171 hours of continuing education taken over a 4-year period. That's a lot of education. It included topics about taxes, auditing, and regulatory ethics. Nothing that I could see in the paperwork about trustee services. But the 171 hours also is just a little more than required to renew his license through 2 periods. And so it doesn't appear that CE, the continuing education, will reflect any rehabilitation with respect to working as a trustee. Mr. Barton submitted 6 reference letters. Half of those are from employees at his firm, Barton CPA. The first letter is from a tax employee who praises Mr. Barton's leadership, mentorship, and transparency about his discipline. The second letter is from his wife of 28 years, who is a firm employee. She lists some of the same changes at the firm that are listed by Mr. Barton in his petition. She adds that the firm also spends $30,000 a year on a growth and compliance consultant, and claims that the firm adopted standard operating procedures very similar to what a big firm would have. She notes that Mr. Barton has been a devoted father to their 2 special needs adopted children. And she tells that Mr. Barton has improved as a CPA and has grown the firm since his discipline, that he's been different and better since this board disciplined him. The third letter is from an enrolled agent who has worked for the Barton firm for about 8 years. She reports that the firm has adopted better controls and quality standards, and her position is focused on compliance. She claims that that Mr. Barton leads the firm with a focus on maintaining high professional standards. None of the employees, however, says anything about Mr. Barton's competence or preparation to do trustee work again, which is the focus of today's hearing. 2 reference letters are from attorneys. The first has known Mr. Barton for 17 years. They have referred clients to each other, and this attorney reports that Mr. Barton has done excellent work on complex assignments, that he's honest and dependable. Similarly, the second attorney reports having known Mr. Barton for 15 years, reports successful collaboration with him on estate planning, trust administration, tax strategy, and probate work. So this is a reference from someone with knowledge of his past and his work as a trustee. They've referred clients to each other. This attorney also claims that Mr. Barton has volunteered and donated to area charities, but provides no specifics. Finally, there is a reference from a professional fiduciary who has known Mr. Barton for 12 years. She reports that Mr. Barton has strengthened his internal practices, refined his client communication processes, and developed a firm culture centered on accountability, transparency, and service excellence. No details were provided about that. And the letter also doesn't describe her basis of knowledge for saying those things about the firm. At any rate, that concludes my summary of the evidence in your packet. Mr. Barton has the burden of proof, and once they're done with their presentation, then I'll have some questions for Mr. Barton. Your Honor.
Thank you, Mr. Dakar. Mr. McCauley.
Yes, thank you, Your Honor. Members of the board, I'm here assisting Mr. Barton, who has been a licensed CPA for over 40 years, in his attempt to remove the restriction on his license precluding him from ever serving as a trustee. The failures which led to the imposition of discipline were caused by his handling of 2 related trusts, notifications that were to be provided and the like, as well as errors in the filing of tax returns filed on the trust's behalf, primarily related to the 2014 tax year. There is not now and has never been any allegation or inference of intentional misconduct or self-dealing or anything of that sort. He has candidly acknowledged the errors made by him, including the tax return errors, a lack of oversight of others who assisted in their preparation, and reliance upon the trust attorney, for matters that were his responsibility when he was assured that certain notifications would be provided by the attorney. He has been absolutely and completely transparent with employees, clients, and prospective clients about the situation. He has acknowledged his mistakes by entering into a stipulated decision and order and has complied with and exceeded every term of his probation. That probation expired in 2024, and this is the remaining restriction. This entire event, which is the only time that disciplinary charges have been lodged against him in his entire career, has been a profoundly sobering event for Mr. Barton. He feared for his license, his firm, and their 20 employees, and has had his eyes opened. He is absolutely committed to ensuring that nothing like this can ever happen again. We will establish through Mr. Barton's testimony that he has undertaken and implemented massive changes at his firm, again, in order to ensure that nothing like this can ever happen again, and that every possible accounting and ethical standard is fully adhered to. On a personal level, he now approaches his work with deep humility and an absolute intent to make sure that everything done by him and his firm is beyond reproach. We have submitted multiple third-party letters, which you've just heard described, and they include letters from professional fiduciary and attorneys who have worked with him on an ongoing basis in the field, including estate planning and trusts. Mr. Barton seeks to have this restriction on his ability to act as a trustee lifted for a number of reasons. However, as he will candidly acknowledge, he does not intend, other than it may relate as to his special needs children's trusts and any family-related trusts, to act as a trustee if he can help it. I imagine there might be extraordinary circumstances, but that is not an intended part of his practice. In the event that he were to act as a trustee, he has thoroughly familiarized himself with every obligation and is acutely sensitive to what needs to be done and when it needs to be done. His reasons for seeking this is, frankly, to remove a restriction on his license, which is a permanent stain. And given the fact that he anticipates transitioning out of his firm in the next 5 to 7 years to leave a clean practice which can be provided to others in the future. And he thinks it will assist in his representation of client, ultimate transition from the practice, and therefore respectfully requests the board to grant this petition. As will be shown, there have been enormous changes implemented on a systemic basis, which would ensure that nothing like this could ever happen again. I thank the board.
Thank you, Mr. McCauley. You indicated Mr. Barton is going to testify this morning.
Yes, Your Honor. If I may call Mr. Barton to testify.
Mr. Barton, would you please raise your right hand, sir? Do you solemnly swear or affirm under penalty of perjury that the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you, Mr. Barton.
Thank you.
McCauley, please proceed.
Thank you, Your Honor. Mr. Barton, how long have you been a certified public accountant?
Before I answer that question, though, I just want to thank the CBA for allowing me to participate virtually. I think I had surgery 15 months ago and I'm still recovering and I can't fly. So thank you for that. I've been practicing for a little over 40 years. I was certified in 85, and so it's been 40 years in 1 month.
And in that 40 years of practice, has the board, other than this one instance, ever made any disciplinary charges against you?
No.
And are you a member of a firm?
Yes, Barton CPA.
How long has that firm been in existence?
That's 17 years under either Barton CPA or Gregory D. Barton Inc.
And how many employees do you have?
20 at the moment.
Now, to revisit briefly the events that bring us here today, you have been disciplined because of your handling of two related trusts in your capacity as a trustee That is, things that you didn't send out in a timely fashion and errors in filing income tax returns on their behalf, correct?
That is correct.
There's never been any allegations of intentional misconduct, self-dealing, or anything like that, have there?
No,
And you've entered into a stipulated decision and order, correct?
that is correct.
And you did so because you acknowledged the mistakes that you had made, correct?
That is true.
Why did these events occur? What led to the errors, in your own words?
It was a lack of oversight on my part. I basically delegated to people that I probably should have been monitoring more closely, which I didn't. I used the trust attorney, was supposed to be sending out notifications on behalf of the trust, and really I should have been following up on him to make sure that was happening, and it wasn't. So what is that line? The buck stops here, the buck stops with me, and I fell down on my duties.
Bottom line is, as the trustee, it's your responsibility, correct?
That is correct.
Okay, and you understand and acknowledge that, correct?
That is so true.
Now, under the terms of the stipulated decision and order, were you placed on probation for a period of 3 years?
Yes, I was for 3 and the firm for 2.
Okay. And has that period been completed as to both?
Yes, it was completed in 23 for the firm, 24 for me.
Have you fully complied with each and every term of the stipulated order?
Yes,
I believe one of the terms was to pay $15,000 over a 2.5-year period. Did you do that?
yes, we paid it early within the first 6 months.
Okay. And submission of quarterly reports, did you do that?
Always on time.
And you were to complete certain specified courses. Did you do that?
I did.
And in addition to that, you have continuing professional education requirements as any other accountant does, correct?
That is true.
And have you fulfilled all those requirements? And have you complied with every other provision of the stipulated decision and order?
I believe so, yes.
Have you fully adhered to any restrictions on acting as the trustee?
I have.
What did you do?
When the stipulation came down in August of 31, I contacted, financial advisors that I was the trustee on trust and told them we needed to be replaced. And I explained why. And they understood. And also I helped them find new trustees. I've told my clients where I've been named as trustee in their trust that they needed to change that out and remove me. And again, I explained why. I've never shied from this. It's humbling and embarrassing, quite frankly. And so it's just, I've been transparent with everybody. I've had attorneys contact me and say, hey, I'm setting up a trust. Can you be a trustee? And I'll tell them no, and I'll explain to them why as well.
And have you been absolutely transparent with all of your employees about this as well?
Absolutely. When this came down, I called a staff meeting, told everybody, the remote workers, we called them, I called them as well, and I talked to them too.
Now, before getting into the changes you've made in your own practice and throughout your firm, what has been the impact upon you personally from having disciplinary charges filed?
Oh, wow.
Entire experience.
Yeah, it was really a humbling and humiliating experience, and it still is. And it took an emotional toll on me. I take my profession to heart. I love what I do, and I love helping clients. I tell my staff, we have our name, and it says CPA. I tell them the P always stands for public, and I remind them that probably 3 or 4 times a year in various meetings. So I've taken that to heart. And so it was really eye-opening that I was careless in my handling of the accounting, and I delegated, which I should not have done so deeply. I should have been more hands-on with it.
So you've taken it deeply to heart.
Absolutely.
Okay. Now, what measures, let's talk about measures that you have taken, both personally and throughout your firm, to make sure that nothing like this can happen again. Have there been measures you've taken?
Absolutely. And I'm proud of what we've done so far. And when I say we, I work with the team.
So you've let every employee know about this?
That is correct.
including new employees as they come on?
That is correct.
Have you cautioned them that you make absolutely certain that every I is dotted and T is crossed when it comes to accounting or trust work?
Correct. We have multiple levels of review in place now. We've identified our tax returns that we do between tiers. I have my work reviewed. I do the higher end tiers. We've elevated and we hired an executive that was with H&R Block. She's become an enrolled agent. She's also the director of tax and compliance in the firm, and she has been overseeing all of the compliance issues. So if I do a return, she will review my work, vice versa. We put in a secondary reviewer as well. So on the complex returns, those will be reviewed by once and then by a second person.
All right, so do you have somebody called now, a director of tax compliance?
I do.
Is that the person you just mentioned that was a former director of H&R Block?
Yes.
And she's an enrolled agent?
She is an enrolled agent, yes.
And does she have responsibilities that others did not have previous about reviewing the work done to ensure compliance with accounting standards?
Yes.
What obligations does she have again?
She basically reviews a lot of the returns as I do. She reviews my work. She prepares tax returns as well. She is a trust specialist and phenomenal. She interfaces with legal firms on trusts and financial advisors, as well as family members of trusts.
Is that Kathleen Sinkus?
That is her, yes.
Okay. And did you create a position of chief operating officer as well?
We did.
And was that the former firm administrator?
It was. We elevated him as he took on more responsibilities, more roles. He's involved in our internal controls. We've adopted standard operating procedures, and he makes sure those are adopted. All employees have them. He works with them on training them as well. And we review those constantly throughout the year.
And is that Chauncey Thompson?
That is him.
Now, prior to this, did you have an executive team? By this, I'm referring to the entire disciplinary situation.
Yes, we had an executive team, but we elevated, then this came down to meet weekly. And what the executive team does is we bring standard operating procedures to the meetings. We review them as a team. And if we're going to implement some, we make changes, then Chauncey will instruct the employees what we're doing. And we get feedback from employees as well. Does this work in your area? And we try to make it a collaborative environment.
Who's on the executive team?
It's Chauncey, it's my wife, Kathleen Sintos is on it, and me.
And do you hold weekly meetings?
We do.
And during those meetings, do you review deadlines for projects and for employees?
We do.
And do you review and comment upon the quality of the work and the checking that's gone on?
We do.
And are those things which are relatively new?
They're more robust, so yes.
Okay. Now you mentioned something about assigning tax returns, for example, with levels of tier 1 through tier 5. Was that correct?
That is correct.
All right. Are the tax returns by employees reviewed by members of the executive team and others for completeness and accuracy?
They are.
On how many occasions are they reviewed typically?
Tier 1 and tier 2 returns are reviewed. Once the preparer is finished, they're reviewed one time for cleanup. If there are any changes, they go back to the preparer. The more high-end returns, tier 3, tier 4, and tier 5, they're usually reviewed by two people. One would be if I'm doing the preparation, Kathy would review my return, and then any questions she has, I will answer, and I will either send it to her or I will send it to another CPA to double check my responses to Kathy's reviews.
And who would perform the second review?
It would be either at this time Sharon. She's one of our CPAs.
All right. Now, this applies to you as well?
That is absolutely true.
So any of your work is now subject to the double review.
That is
just
correct.
as any tier 3, 4, 5 review would be, correct?
Correct.
Have you upgraded your software or purchased new software for deadline tracking or other purposes?
Yes, we have. We've been under the Thompson suite for 12 years, and under their program, we've had the practice tool. When this came down, we went back through it, we reorganized it, we made it more friendly for us and easier for us to track. We lined up queues to be worked on. We assigned who was going to do the queue. We review who is signing those weekly, and we make sure we can track the timeline on them. We're reviewing work queues constantly throughout the year. And then we've tried other software implementations. And the latest one we're now doing for our bookkeeping clients is, and accounting clients is, we're using Financial Sense, where we can track. I will basically watch it daily to see how our staff is progressing through doing the accounting projects.
Okay. Any other practice software you've implemented?
Well, like everybody else, we're using AI a little bit more for research and stuff, but for the most part, we're really focused on the tax side and the Financial Sense to make sure we're up to date.
Have you implemented improved and enhanced calendaring and tracking software and new protocols and procedures beyond what you just described?
Yes, we spent $100,000 upgrading our software and hardware system, and went with a cloud-based system that is managed off-site. And with that came better calendaring, due date tracking, more compliance with the firm where we can all come together and talk. And like I mentioned before, we've implemented standard operating procedures throughout the firm, and on that, they are updated constantly.
Did you hire outside consultants to assist you?
Yes.
What are you referring to?
We've hired I call her a business coach. And what we did was we brought her in to coach not only me, but anybody in the firm that needs it on communication, deadline management, following up with clients, doing SOPs. She talks to the staff personally about how the firm can help them grow, what they need, so they can feel free to talk to her, as opposed to coming to the executive team and saying, I need this or that. They can feel free to talk to her, and then she'll report back to us and deal with it. She's available for them to call if she has questions or concerns about something internally or how to approach a client outside of the team that we have here.
Do you hold annual retreats?
We do. We hold a firm-wide annual retreat in usually the beginning of tax season in January. We just finished ours a couple of weeks ago. And at that retreat, what we do is we go through the standard operating procedures, those that have been adopted. We work with our staff and talk about them, what's working, what's not working, can we change those? We talk about things that we've seen throughout the year in tax returns. And then more importantly, we really work to coordinate the whole issue with the staff and bring them around so they have buy-in with us and they know what's happening. At those meetings, I will report to them early on in 21. Actually, it was in the first meeting was in January of 22 after the stipulation. I then repeated to everybody in the meetings that, as you know, this is what happened. I explained it, and I told them, this is a humbling experience for me, and hopefully, so pay attention and let's make sure we button up everything as we continue to move forward.
Now, there were comments made by the Deputy Attorney General about the CE, continuing education, not relating especially to trusts. Have you, whether through continuing education or on your own, refamiliarized yourself and made sure that you're conversant with all obligations imposed upon a trustee and reporting requirements, particular tax issues and the like?
I've done it mostly from the trust tax preparation issue, as my restriction was I cannot be a trustee. And quite frankly, I never want to be a trustee. It's the juice isn't worth the squeeze, so to speak. And I even tell my friends to call up and say, hey, I'm going to be the trustee of a trust. I tell them, run and resign, get somebody else to do it.
it's just not worth it for me. So I fall more on the tax compliance side and tax training versus actually trustee duties.
But why then are you indicate that you're not, well, let me step back for a second. So you've talked about all these changes that have been implemented throughout your firm, and they
Correct.
cover you, apply to you as much as anyone, correct?
Correct.
So your work is as subject to double scrutiny as anybody else's, correct?
That is correct.
But let me ask you this. On a personal level, has there been a change in just the way you approach your work?
Absolutely. I take a moment, and if we're bringing on new clients, we evaluate them. I evaluate them. I'm well aware of if there's anything sketchy with a potential new client, we will not take them on. We've let clients go, and I've instructed staff to let clients go that we could see we're going to become problematic. Personally, I took this to heart. It's when it happened, that was very frightening for me. I thought I was going to lose everything and everything we had built, and I felt bad for the employees, and I felt bad for my clients, and because I think I've built up really nice relationships with my clients as well. And when a client leaves us and fires us because they're moving out of state, I always take it personally. Oh wow, they're firing us. And I've learned through humility and this whole process that it's just been daunting.
You mentioned that you don't anticipate, let's put it this way, you don't desire to act as a trustee anymore, correct? So the question then becomes, why is it that you're seeking to lift a restriction that you're not planning to use anyway?
A couple of reasons. One is that I'd like to leave the profession when I retire in the next 5 to 7 years, or whenever that will be, with a clean record. The other issue that I look at is as we exit, and we ran into this when we did an acquisition, we acquired a firm and they were the trustee on several trusts. And part of the acquisition, I had to inform them, we cannot take on the role of trustee. And I explained why. And it just kind of, drew them back a little bit. I would like to not have a blemish on my record. So when we do go through whatever that exit strategy is, it's not a question for due diligence. It's clean, and they can, because what happens if I merge with a firm that does a lot of trust work, and I don't want to be scrutinized at that level with them.
Now, do you have various family-related trusts that you can no longer be trustee of?
According to the way I read the stipulation, that is correct.
And for example, you have 2 special need children?
I have 2 children that we personally have been setting up special needs trusts for them, or actually trusts, not special needs per se, but just trusts to control what they have happen. I'm sure I am named in my mom's trust. I'm an only child, so I'm named in my mom's trust as a trustee. And, if and when she passes away, I would expect they would ask me to fulfill those duties.
Which of course you would do
Because it's family.
Absolute attention to every obligation that there might be upon a trustee, correct?
Correct.
Okay, so as you read the order, you are now precluded from even being involved as a trustee on behalf of your own family members' trusts, correct?
As I read it, yes.
So would it be fair to say that you don't intend, other than perhaps in family-related matters under extraordinary circumstances, to act as a trustee in the future, but you want to have a clean record, and you want to avoid, to eliminate this permanent blemish upon your record, and also to make matters easier if and when you transition out of accounting?
That is absolutely correct.
And that's your reason for seeking to have this lifted, not a particular desire to act as a trustee anymore.
That is correct.
Are there anything that you would like to tell the board on a personal level that I haven't covered?
I think, again, I would like to just thank the board again for letting me participate remotely. I think I've taken this really to heart. And as I said earlier, this is a humiliating and humbling experience for me. I try to live my life with full transparency, And I tell my staff 5 minutes today will save you hours down the road. This was one of those moments where I didn't take my own advice and do 5 minutes today would have saved hours and humiliation down the road on me. So for that, I am deeply sorry, and to the board and the profession and me and my family and my 20 employees.
Thank you. No further questions at this time.
Thank you.
Thank you. Mr. Dakar, questions for Mr. Barton?
Yes, thank you. Mr. Barton, you said that your firm has 20 employees. How many office locations does your firm have?
We have 2 full-time offices, one in Palm Springs and one in Palm Desert. And then we have a remote office out of Palmdale, Lancaster. And then we do a pop-up office in tax season in Redlands.
Amongst those 20 employees, are there any other CPAs?
Yes, there are three or four CPAs, a couple of enrolled agents, and C-Techs. So what we do is we have a C-Tech. We then help them get training and education to move to become an enrolled agent or to be a CPA if they want.
Have any of those 20 employees served as a trustee before?
I don't believe so.
Could some of them serve as a trustee if your firm merged with another and needed to do trustee work?
They could. It would be up to them whether they would take it on. I would strongly advise them not to.
You've touched on this issue, but why should this board believe that you're ready to provide competent trustee services going forward? Because you're going to have the ability to do it. What if you do it? Why should this board believe you're going to do it competently?
I think because I've learned my lesson by this. I think we've adopted really good internal controls around the firm on meeting obligations. And what we do now is when we get a project, we lay out all the due dates and we track them and we map them. So we're constantly following up on it. And I think it's demonstrated. I'm in the community. We are philanthropic in our community. We are involved in the community on various charity levels of giving. And, once bitten, twice shy, I think is the term. I think that that's really the case here. I just have no desire to be a trustee again, as I've mentioned throughout. But, if it happens, I would certainly lean into it, and I would then find a way to have a fiduciary step in and be the trustee for me, or have the attorneys or somebody find out.
Have you done anything to improve your personal skills and abilities to serve as a trustee?
I've continued to take continuing education. I do a lot of reading. I pay attention to what's going on around me in the trust world. And so I think that really kind of covers what I've been hitting on.
Turning back to the misconduct, to the trusts in which you ran into problems, did you do anything to make amends to those trust clients?
By the time the stipulation had come down, we had finalized the 20 return and finalized all the trust returns at that point. I did not go back and do anything to make amends to those clients. We counted for every dollar that was inside there. There were errors. I don't believe the dollars were of high magnitude. I'd have to go back and check. But yeah, that's kind of where I stood with that. And I know that the person that brought the complaint to the state board originally, I had heard he had tried to bring up litigation and went to a couple of firms, and both firms said he didn't have a case. And my attorney for the trust, who was responsible for helping me navigate this, had said there's nothing really for him to do and go forward. So then he turned to the state board and filed the complaint.
If this board restores your ability to work as a trustee, but you don't serve in that capacity for a number of years, would you be rusty, you think, if you tried to do it later?
I know what I would do is that if my license is restored, I would start this year taking more courses for acting as a trustee and communicating with my attorney clients and friends and getting more information from them to beef up my skill set so that if and when that came, I would be prepared.
Your Honor, those are all the questions I have. Thank you, Mr. Barton.
Thank you, Mr. Carr.
Thank you.
We will now open it up to questions from the board, starting with Ms. Dong.
Losing people.
Thank you so much for your testimony today. Just my first question was to actually our Mr. Drucker. In terms of the restricted practice, is that on the respondent himself or is it on his firm? So is this firm able to handle trustee cases or are they barred from doing so?
Yeah, I don't believe that the people at his firm are barred from, other people at his firm are barred from doing it. The restriction is upon Mr. Barton himself.
Okay, so when Mr. Barton said he couldn't, when he had acquired another firm and he couldn't take on the clients, certain clients because they were trustees, they could have if they had CPAs who were qualified to do that type of work.
I believe that is true. I believe the firm literally could do it. No,
Right.
The firm's not restricted. Yeah. Staff indicates that the ongoing restriction is upon Mr. Barton only.
Okay.
Correct.
Yeah, and this petition is by Mr. Barton only.
Okay, thank you. And just one question for Mr. Barton. Thank you so much again for presenting all the different things that you've done in the past couple of years to rectify some of the mistakes that were uncovered in the investigation. So one thing that I noticed in the investigative hearing was that they had uncovered a lack of oversight on monthly bank reconciliations, which is a very, tick and tie. That's something that should be done as a common practice really for any CPA firm. So can you just sort of address how something that is so bread and butter for a CPA firm could have been overlooked?
Yeah, that's really a great question. And it's one of the embarrassing moments because I prided myself in my early career as an auditor. So it was always tick, tie, and verify. When that was coming, I had delegated to a CPA in our firm that he had really strong accounting skills. And the oversight was he wasn't reconciling the bank accounts. And when I was reviewing, I wasn't doing a deep dive on it. And so it's just total lack of verification on my part for that. And what we do now as part of our process is that we have a matrix that if we're doing accounting work, before it moves to the next step, there are bank reconciliations done, all the reconciliations are done, so we know what's going on with the client.
Thank you.
Mr. Lin, questions? Ms. Lana?
Thank you, Mr. Barton, for attending. You mentioned that you utilized the Thomson suite of software and that you've implemented enhanced SOPs that include 2 layers of review for your more complex returns. Do you utilize any compliance checklists as part of your procedures?
Absolutely. Kathy, our director of compliance, she uses, I can't remember what she's using, Thomson. There's a Thomson suite that she uses for research and compliance. She'll use BIA, I think it is. She's got access to other ones. Usually what will happen if we work together on issues. So if there's an issue that I see in a return, I will go to her and say, let's ferret this out. She'll research it. I'll research it at the same time. We'll then come together to come to a conclusion that makes sense and meets all the various guidelines. So we're and staying in compliance. And she follows all the trends as I do, but she's more deeply into following all the trends that are happening in the tax world.
Thank you. I have one follow-up question. Are those checklists utilized for every engagement in your firm?
For the tax engagements, we have checklists. For our accounting engagements, I think in our firm now, we only do one reviewed financial statement. So we do all the checklists and all the documentation for that. We moved away from compilations and we're just doing prepared financial statements. So each team member has a checklist to make sure the bank recs are done, everything is done, and it's picked off so we can follow it. So if one of them gets stuck, we know anybody in the firm can look and say, oh, hey, Des, you're behind on this, what's happening? And so we can then lean in and help get documentation and find out if she's struggling.
Thank you. I have another question. So can you give me some context around what was going on in your business at the time that these trusts or the incidents occurred that led to the mishandling of these particular trusts? Was there anything specific happening, anything out of the ordinary, or what was going on in your business at the time?
We've always been in a growth mode. What happened in that period of time was we were in a transition period from another firm we acquired where the CPA was aging out. We were dealing with his mental issues at the time, and I was distracted a lot with that. And quite frankly, it just lack of oversight on my part, and I dropped the ball.
Thank you. No further questions.
Thank you.
Mr. Aguilar,
No questions. Thank you.
Ms. Batchelor?
Good morning, Mr. Barton. I have a question about your executive team.
Yes.
You said this team has been put in place for quality control as well as review for any work that finally exit the firm in terms of a completed package that's ready to go. My question to you is your credentials for the quality team. What are their credentials and what is their experience?
They don't oversee final product. That is done by the CPAs, me mainly, and our enrolled agent, Kathy, where we make sure the returns are put together to go out. The executive team is really to function on SOPs, what issues are being brought forward. Do we have personnel issues? Are people being assigned returns that are not to their level yet? We talk about, obviously, firm budget matters. Acquisitions come through the executive committee. They're not responsible for pushing product out the door.
Okay, thank you for that. And besides the CPA and an attorney, also professional trustees could also take on trust responsibilities. Do you have any of those?
Not on staff, but we do refer to a couple of them in the Palm Springs area.
Okay, thank you. No further questions.
Thank you. Mr. Rafel?
Thank you. Thank you, Mr. Barton, for attending this morning. It was noted by Mr. Dakar that you had engaged in some volunteer activities. My question is, have you or your firm done any volunteering or pro bono work in the tax or audit field for nonprofit groups or other sorts of organizations in Palm Springs, Palmdale area?
We have done limited pro bono work for some small charities. We've done accounting work for some nonprofits. We not pro bono, but we will reduce our fees based on the organization. And then the involvement that we have, we really focus on educational issues that we're involved in. We are focusing on women's issues in the Palm Desert, Palm Springs area. And then we also are involved in the LGBTQ community through sponsorships and assistance. And sometimes we'll lean in on a board question. They may have a tax question. We may respond. Very unlikely though, but that's who we kind of support now.
Thank you for your answer. No more further questions.
Thank you. Ms. Tu?
Thank you. Thanks for being here again, Mr. Barton. All my question has been asked previously, so I will pass.
Okay. Ms. Corrigan?
Thank you. No questions.
Ms. Zielinski?
Yes, thank you. And thank you for being here, Mr. Barton. During your testimony, you mentioned that you are trustee of two of your children's trusts and potentially your mother's trust. And so the permanent restriction may have an effect on that as you read the order. But my understanding is the way that the order is written is that you can either request the CBA for reinstatement, but another avenue to be a trustee for your family trust is, quote, or be appointed as a trustee by the probate court. So when the time comes, is there any reason why you couldn't just seek to be a trustee for your particular family trust through the probate court?
I would defer that question over to Noel because the way I read it, I read that I could not be a trustee ever in my life. So I rely on Noel to tell me whether I can be a trustee or not.
If I recall correctly, I believe it prohibits from being appointed, but I'll double check.
Okay, and I have another question. Again, regarding your executive team, just to follow up to that, why isn't there a CPA on the executive team along with you?
I'm the CPA that's on the team. Are you talking about having a second one on the team?
Correct.
Oh, yeah, we've talked about it, and it's something we talk about all the time when we're hiring. The last hire that we tried to bring on, we dangled that cord out in front of him that we'd like you to join our executive team as well. So we're trying to find one. I don't believe maybe one of our CPAs is now qualified to join the executive team. But when it comes to our executive team, we're talking personnel issues. So we try not to, how wildfire spread. So we don't want to have somebody on the executive team that's not going to keep it close to their vest.
Understood.
And we discussed compensation and bonuses, and it kind of became a situation where, look, let's keep it close so we monitor what is disseminated between the staff.
I have another question. You mentioned during your testimony that one of the issues that gave rise to the complaint was that you entrusted a trust attorney, and you believe that he or she was responsible for the deadlines. Are you still in a referral relationship or in a relationship with this trust attorney who you mentioned?
No, he died suddenly before the hearings in the summer of 21 because he was going to be one of my witnesses, and he dropped dead. So I can't be with him.
Thank you. No further questions.
Ms. Thompson?
Yes, I have one question for Mr. Barton. In your rehabilitation testimony,
I'm sorry, he dropped off. Oops.
It looks as though we have lost connection with the CBA meeting room.
Okay.
Hold for one moment while we
I'll
do
hold.
some. Thank you. And apparently the internet dropped in the building that the board was in. We will give them a moment to see if it recovers, as sometimes happens.
Well, I was worried yesterday about this when we heard there was a massive Microsoft outage and Amazon outage throughout the nation.
Right, exactly. The internet is wonderful when it works.
Life,
So,
life used to be so much easier before the internet.
well, in some ways, yes.
Right, I was going to say in some ways.
Please hang on while I find out from the board what they choose to do next about this hearing and the conclusion of it. Thank you for your patience.
Yeah, thank you.
Okay, yes, the moderator let us know as well, so I think it's coming back. Okay, thank you, Denise.
And yes, this is the moderator. We did hear you and we do see
Mr. Barton,
you.
can you hear me?
Yes, I can hear you now.
And can the board hear us? This is the moderator checking to see if the board can hear the WebEx. And testing audio. We lost the video. Someone mentioned they were using a hotspot, so that might just not be possible to support the bandwidth. We will continue to work on it, and thank you for your
No worries.
for your patience.
And Mr. McCauley, can you hear me?
I can. Who's this? Hello?
And to the board, can you hear the WebEx?
Members of the board, can you hear me?
Mr. McCauley, can you hear us?
Let's-
I can hear you.
Okay.
Yes. Yes, I can hear you.
All right, I have a Teams chat going and we are frantically communicating what we might do next. And again, thank you for your patience with this.
Absolutely.
Thank you. I'm emailing the attorney.
Mr. Barton, we can't hear you.
I'm here. Can you hear me now?
Okay.
Can you hear me?
It would appear not.
Okay.
There is the suggestion of stopping video. I don't know if that would be, I will propose that to the board.
Okay.
And this is the moderator. Again, we do have video. I do not know if you are hearing us in WebEx.
I'm hearing you, Ann.
Yeah,
I hear you.
okay. It appears that the room does not, though. Staff are working on it, and I will keep you posted. Thank
Okay.
you.
Thank you.
Like this. Can you hear me? And
I can hear you now. Can you hear me?
CBA. So we're on hold for.
this. Hold on.
Information on that bar.
I do hear Manny, but you do not hear
Okay.
us.
Yes, I can hear you now.
Oh, all right.
I think we're back in.
Wonderful.
Are we
All
back?
right.
All right, Mr. McCauley, can you hear me?
Yes, I can. Who's this?
This is Judge Block.
Oh, yes, Your Honor, we can hear you.
And Mr. Barton, can you hear me?
I can hear you too, Your Honor.
Okay, fantastic. Mr. Bernard, ready? All right, we're back on record. The parties are present. A quorum of the board is still present. And Ms. Thompson, I will turn back to you.
Yes, Mr. Barton, one question for you. In your rehabilitation testimony, you note that immediately following the settlement, you executed something called rapid turnaround milestones. Can you provide some specifics around what those milestones were, how you determined that they were relevant, and how they were reviewed to determine if they were implemented correctly?
What we did was the first thing is timeliness of our staff, making sure they respond to emails and clients' inquiries within 24 hours. To document what their inquiry is, make sure it's put into our file system when they're done talking to everybody, so that the next person in line, if somebody answers a question and the client calls me, I had direct access to it as well, so I can then further advise. And we've done that with not only communications, but tax returns. As we bring them in the door, we set a target goal to hit them in a certain period of time so they move out the door.
Okay, and then to follow up, these milestones of timeliness, documentation, deadline management, I'm presuming, were they new, or was there anything in existence similar before the settlement?
These were more robust, meaning we were tracking them. Chauncey, who at that time was our administrative officer, then became the CEO. He was instrumental in making sure that compliance is met. For example, he will walk around the room, the office a couple times a day and check in with staff and see where they are on their follow-up list with clients and or projects, so that we are not missing deadlines and we're done well ahead of deadlines. So we had it, but it wasn't to the level we have it now. And that's one of the things that we've been implementing, and we look at it annually, is what can we do to help streamline the process to give our staff and our clients a better experience.
Okay, thank you, Mr. Barton. I have no additional questions.
Ms. Hines?
I have no questions.
Mr. Durkar, any follow-up questions?
No, Your Honor.
Mr. McCauley, any redirect for your client?
No, Your Honor.
Just open it up to the board. Is there any other board members that wish to ask any further questions? Ms. Batchelor?
Hello, Mr. Barton. I have one more question for you.
Absolutely.
The clients that are party to this case suffered penalties and fees from the taxing authorities because of the late filings. Did you make some type of communication or any kind of let's say means to pay these fees and penalties for them, or anything like that?
The beneficiaries did not. It would have been the trust that would have had fees and penalties. And to tell you the truth, I can't recall whether fees and penalties were ever imposed on the trust that we had to pay.
It seems like in our writing, Mr. Drakar, maybe you can explain that to me. In terms of this case, there were penalties and fees upon the trust because of the late filings. Is that correct?
Member Batchelor, I can't confirm that.
Okay.
And I will, and can I interject? The returns were never late filed. The returns were always filed on time. And if there were taxes due, they would have been paid either at the time of filing. So there may have been penalties, but I can't recall whether there actually were.
Okay, and then it was a property, I think in the South, where property taxes were supposed to be paid at a certain time. And one of the members of the trust, one of the beneficiaries, drove around 100 miles or so to get those taxes paid because the sheriff was about to abate the property because of that. Do you recall that happening?
I recall parts of that. And I think he personally over exaggerated. When the property tax bill came in, the trust paid it immediately
On time?
on time. When we got it, it got paid. So it may have had little penalties on attached to it, but it was not as dramatic as he made it out to be.
So you would say those penalties and fees that were imposed by the property tax authorities were de minimis? You would,
I can't recall. I'd have to go back and look now.
okay, all right, thank you. I was just curious about that.
No worries.
Thank
Thank you.
Any other questions from the board? Mr. Durkar, do you wish to make any closing remarks?
Yes, Your Honor.
Well, actually, before we get there, Mr. McCauley, any further witnesses or evidence?
No, I do have one follow-up question if that's possible.
For myself or for the board?
For the witness.
Oh, go ahead.
Mr. Barton, if a beneficiary incurred any expense by personally paying property taxes, would he have been reimbursed by the trust?
He would have been, and if it was my fault, if he had requested it from me, I would have reimbursed him.
Thank you.
Thank you.
Thank you. Mr. Durkar.
Thank you, Your Honor. The petitioner has the burden to demonstrate that he is rehabilitated and should be released from the practice restriction. On the one hand, Mr. Barton seems to demonstrate insight and contrition about his prior misconduct. But there's a bit of a conundrum because Mr. Barton is barred from serving as a trustee, and he's petitioning to be able to do trustee work again, but he doesn't plan to work as a trustee. He seems to he's asking for this relief to improve his professional standing and to help him apparently grow his firm and move it forward. He won't be doing the trustee work to improve or maintain his trustee skills, but years from now, he could jump into the role because you would be giving him the ability to do so. Would he be ready at that time? That is a public protection concern, and it's something to think about. And with that said, I think you do have all the information that you need to make a reasoned decision on this matter. Your Honor.
Thank you. Mr. McCauley.
Yes, Your Honor. Your Honor and members of the board, Mr. Barton has testified that the failure that led to the imposition of discipline were limited to his handling of two related trusts and errors in filing tax returns on their behalf in the 2014 and adjacent years. There is not now and has never been any allegation of self-dealing or intentional misconduct. He has candidly acknowledged the errors made by him been completely transparent with employees, clients, and prospective clients, fully complied with every term of the probation, and implemented massive changes in his personal practice and in his firm's practice. Moreover, as you've heard, this entire event has been a profoundly sobering event, and he now approaches his work with deep humility and caution and an absolute intent to make sure that everything done by he and his firm is beyond reproach. The rehabilitation criteria, which are to be used as the standards in which a petition for reinstatement or a petition for removal of a restriction are to be considered, are set forth in California Code of Regulation 99.1. And they list 13 criteria, most of which, or many of which, are not relevant, such as those relating to criminal convictions of which there never was any brought or asserted. Taking the relevant ones in order. The first is the nature and gravity of the acts. We've acknowledged that they were potentially significant, but this is not an instance of any type of intentional misconduct or lasting harm. Another criteria is the length of time since the offenses. Most of these relate to the tax year 2014, so there are 10 to 11 years past. He completed his probation, which ended in 2024. So that factor militates for granting the petition. The third factor is the extent to which the petitioner has complied with the terms of probation. 100%. He's gone beyond the requirements of the probation. Another factor that's listed is the petitioner's attitude towards commission of violations. And that has been met with a candid acknowledgement, profound remorse, and a complete change of consciousness implemented throughout his personal practice and firm-wide. Fifth factor is the individual's recognition of wrongdoing. That is complete here. The sixth factor is the individual's history of violations. There have been no other violations on this one instance in 40 plus years of practice. And the seventh factor is the nature and extent to which the licensee has taken corrective action to ensure that the violation will not recur. Again, massive systemic changes, both at his firm and in his personal practice, which everyone's work is cross-checked, often on multiple occasions. Now, I concede that Mr. Barton has no plans, except in connection with current or future family-related trusts as to which he should be the trustee. But he seeks to have this permanent restrictions license removed. Now, first of all, there was a comment made that perhaps he could be appointed for his family trusts as by the probate court. That's actually not an exception. His acting as a trustee by appointment by the probate court is expressly and permanently prohibited. And that's on GDP PET 074, item 15 of the restricted practice order, which is the restricted practice order. With that said, he first of all seeks the ability to represent family trusts, of which there are several and undoubtedly will be others upon the passing of certain family members, which he cannot do right now. And there's no question that he would provide the very best services on behalf of his family members. The second issue is that he simply seeks to have a cleaner record with no restrictions on his ability to practice, irrespective of whether or not he plans on practicing in that field, so that he can leave with a clean record after when he departs the field of accounting in 5 to 7 years, which is his current plans. It would also help the firm as it either is taken over, merges, acquires other companies, and any growth. Given that he has met every applicable criteria for removal of this restriction and has demonstrated genuine remorse, full compliance with all terms and conditions of his probation, and implementation of massive changes on his and his firm's practice to make sure that nothing like this can happen again, we would respectfully request that Mr. Barton's restriction on practice be lifted at this time. Thank you.
Thank you, Mr. McCauley. Mr. Barton, I'm sure Mr. McCauley has already had this discussion with you. At the conclusion of the proceedings this morning, the board will go into closed session for deliberations. You and Mr. McCauley will be notified of the board's decision on a date in the future.
Yes, I'm aware of that.
All right. Thank you for that. With that, the matter is submitted for decision. The record is closed and we are off the record.
Thank you, Your Honor.
Thank you.
My understanding is the board would like to take a brief recess between petitions. How long? 15 minutes?
Yeah, that should be adequate.
Okay. Let's take a little bit long. We'll come back at 10:40.
Thank you. This is the moderator. We've concluded this portion and we'll be back at 10:40.
Mr. Bernard, our page count? 58. 58. Thank you.
Technology. Oh, that's right.
Favor?
Yeah.
When you're speaking, can you bring the mic a little closer?
Sure.
Because it's a little, the way these things work, it's just hard to hear if it's.
Yeah.
Part of.
Yes, no problem.
Sure, we use them more.
Okay,
There you go.
thanks.
They tested it the day before. They did everything they could do.
When we go to closed session, we're going to staff day.
Staff day?
Michael.
Yeah, ask him.
Did you hear my questions?
All right, it's now 10:40. Mr. Bernard, are you ready? All right, we're on record before the California Board of Accountancy in the matter of the petition for reinstatement of revoked certificate of Sean Michael Gerald. This is board case number SI 202611, Office of Administrative Hearings, case number 2025110265. May I have the appearance of the Deputy Attorney General?
Deputy Attorney General Ted Durkar.
May I have the appearance of the attorney for petitioner?
Yes, good morning, Attorney Scott Harris on behalf of the petitioner Sean Gerald, who is also present here to my right.
All right, good morning to everyone. We have established before going on record that a quorum of the board is present. I do want to take a roll call just for our record. I would ask that the board members respond when they hear their name. Ms. Dong?
Present.
Mr. Lin?
Here.
Ms. Lotta?
Present.
Mr. Aguilera? Ms. Batchelor?
Here.
Mr. Rafel?
Here.
Ms. Tu?
Here.
Ms. Corrigan?
Present.
Ms. Zielinski?
Present.
Ms. Thompson?
Here.
Ms. Hines?
Present.
All right, thank you. This is the date and time set for hearing on the petition. Mr. Durkar, I will turn to you first to provide an overview.
Thank you, Your Honor. Again, just for the record, I'll state that I appear on behalf of the people of the state of California by authority of Business and Professions Code Section 5115 and Government Code Section 11522 for this hearing on the petition for reinstatement by Sean Michael Gerald. My role is to assist the board members and the judge in fact finding. This role is not adversarial, but is intended to protect the public health, safety, and welfare. If I may turn now to the evidence, Your Honor.
Please.
The board members and petitioner have been provided with a copy of the same petition packet. It totals 334 pages and has been marked sequentially with a stamp of SMG-PET 001 through 334. This packet includes the notice of hearing at page 245. It's kind of sandwiched in the middle there instead of at the end, as it often is in the packets, because there was a supplemental filing by petitioner. Those are the pages that compose about the last third of your packet. The original petition is at pages 5 to 18, and there's a personal statement from Mr. Gerald at page 20. But what I'd like to do is mark the whole packet as Exhibit 1 and offer it into evidence.
Any objection, Mr. Harris?
No, Your Honor, thank you.
All right, Exhibit 1 is admitted.
Your Honor, I'd like to provide a summary of the case.
Please.
Mr. Gerald received his CPA certificate in 2014, and it was a G license, so he was not authorized to perform attest engagements when he first became licensed. To perform attest work in California, Board Regulation 12.5 provides that a CPA must submit a certificate of attest experience signed under penalty of perjury by a CPA with attest authority who supervised the applicant for at least a year, including at least 500 hours of work on attest engagements. In 2019, this is 5 years after he became licensed in California, Mr. Gerald also got licensed as a CPA in the state of Florida. In 2023, an accusation and statement of issues was filed against Mr. Gerald in response to his conduct relating to his application for an attest license, and that pleading alleged that he should be disciplined and his attest application should be denied based on 3 stated causes for discipline: making a false statement in an application, committing unprofessional conduct through a willful violation of licensing rules, and disseminating materially misleading information. That case went to hearing, and the following facts were established as stated in the decision. In November 2021, Mr. Gerald submitted his first application to the board for attest authority, in which he attempted to self-certify the attest experience requirement. CBA staff informed Mr. Gerald that he couldn't certify his own hours and must submit a certificate of attest experience signed by a CPA who in fact supervised him. The next month, December 2021, Mr. Gerald asked a former supervisor to submit a certificate for him, but that former supervisor declined due to the passage of time and the accounting firm's lack of documentation to validate whether or not Mr. Gerald had, in fact, earned the requisite 500 hours of supervised experience. Mr. Gerald inquired with CBA staff if there was another way to satisfy the attest experience requirement because he had acquired it a long time ago, and CBA staff informed him that there is no other way. Then Mr. Gerald asked if the CBA could accept a certificate of attest experience from a former supervisor that is signed with a signature stamp. Staff responded that a signature stamp is acceptable on one of the certificates. In February 2022, Mr. Gerald sent the CBA a new certificate of attest experience from a supervisor, certifying that he had supervised Mr. Gerald for 790 hours of attest work. It was signed with a signature stamp, and the signature was dated in 2006, a full, 16 years earlier. CBA staff noticed that this alleged 2006 signature was on a 2020 version of the certificate of attest experience form. And staff reached out, but was unable to reach the purported signer, this purported supervisor. CBA staff told Mr. Gerald that he'd need to submit a letter explaining why the signature was backdated. Mr. Gerald responded that the supervisor had died in 2008. Then in April 2022, board staff inquired further with Mr. Gerald about this dubious certificate of attest experience, and he responded that it had been prepared and signed in absentia. Mr. Gerald said that he couldn't confirm the supervisor had signed it, but that this was how the supervisor would have signed it had he still been living, and that the supervisor died in 2008. In July 2022, this board, through the Enforcement Advisory Committee, conducted an investigative hearing with Mr. Gerald. Mr. Gerald testified under oath at that, and that transcript from the investigative hearing was some of the evidence at his hearing on the accusation. At the investigative hearing in 2022, Mr. Gerald said that he had worked part-time for this supervisor named on the certificate of attest experience, and that they had a falling out at some point. Mr. Gerald said that the supervisor couldn't fill out the form because he passed away. So Mr. Gerald ordered the signature stamp in the supervisor's name and used that on the certificate of attest experience. He said he didn't know what the supervisor's signature was like exactly, so he made that up when ordering the signature stamp. Mr. Gerald admitted that if the supervisor was still alive, that he probably wouldn't have signed the certificate of attest experience because of the falling out, whatever disagreement it was that they had. Mr. Gerald took the interesting position at the investigative hearing that his certificate of attest experience wasn't a forgery and that he didn't try to deceive the board because of his use of the signature stamp instead of just faking the signature with a pen, as if the more elaborate scheme vitiated or mitigated the deception. Then at the hearing before the administrative law judge on the accusation about a year later in 2023, Mr. Gerald gave very much the same testimony as he had at the investigative hearing the year before. Mr. Gerald made one additional admission before buying the signature stamp and using it to forge the certificate of attest experience. He had talked to a CBA staff member who told him that a dead supervisor cannot certify his experience. At the 2023 hearing, Mr. Gerald, and these are findings in the board's decision, Mr. Gerald downplayed his conduct, even claiming that if he had tried to deceive the board, then he wouldn't have backdated the fake signature. I don't understand the logic to that claim. It doesn't appear that there is any. The ALJ's proposed decision sustained all three causes for discipline. The ALJ found that the forged certificate of experience was a serious violation and was compounded by Mr. Gerald's refusal to acknowledge the wrongfulness of his misconduct at the hearing. Plus, he had submitted no rehabilitation or mitigation evidence. The ALJ noted that Mr. Gerald's conduct raised serious concerns about his ability to fulfill his duty as a CPA to honestly and accurately present documents. The ALJ found that Mr. Gerald did not demonstrate any insight or remorse through his testimony, and the decision called for revocation and denial of the attest application. This board adopted the ALJ's proposed decision effective September 4th, 2023. The decision provided that Mr. Gerald is to reimburse the board over $13,000 in the costs of investigation and enforcement. And since then, Mr. Gerald has paid, I believe, $689 of the $13,000 in costs that are owed in connection with any reinstatement that may occur. I'll turn now to the petition submitted by Mr. Gerald in this proceeding and the supporting documents. The petition form states that Mr. Gerald seeks reinstatement of his G license, that's his general non-attest authority, at page 15, but then his attached letter, which is page 20 of your packet, says that he seeks to be reinstated with an A license. So that's a point that I hope we can clarify here as this moves forward. Mr. Gerald's explanation for why he believes the petition should be granted is that, quote, I have continued to operate in good faith regarding the decision made by the board, unquote. It is unclear to me what that means. He points to continued practice under his Florida license and claims that the Florida board is aware of his California discipline, his revocation, but allowed him to keep his license, did not take action against him. And he reports that he does peer review work in connection with his attest work for Florida businesses. Mr. Gerald says that in his papers that he shouldn't have submitted his certificate of attest experience without a proper and authorized signature, but, quote, it is very frustrating when I have hours from a Newport Beach, California CPA firm that really doesn't want to sign in a deceased CPA. My work is excellent, unquote. Mr. Gerald has documented completion of 169 hours of continuing education that were completed from September 2023 through December 2025. And most of your 334-page packet is composed of those continuing education certificates and worksheets. Mr. Gerald submitted 8 reference letters, including 6 from clients in California who speak of his continuous accounting service to them for many years. None of these 6 California clients expresses any knowledge that Mr. Gerald's California license was revoked. In fact, the letters demonstrate that they seem to think they're writing in support of his application for a California license versus a petition for reinstatement. The California clients refer to his longtime and ongoing work for them, including 2 clients who report that he does their taxes. Those are at pages 27 and 31 of your materials. Since his revocation, it does not appear that Mr. Gerald has any authority to prepare tax returns for a California client. That is because he's revoked by this board. He's not an enrolled agent or a CTEC. He is a CPA in Florida, but practice privilege doesn't authorize him to prepare taxes for California residents without first obtaining permission from the CBA, which he never requested. And Your Honor, the authority for that is at pages 331 and 333 of the materials, specifically Business and Professions Code, Section 5096, Subdivision H1. In conjunction with Section 5096.2, subdivisions A1E and A2B. Thanks for bearing with me in that technical recitation of statutes. Another reference letter that Mr. Gerald submitted is from a former part-time employee of his who reports having worked for him for about 1.5 years with unspecified duties. This former employee reports that the office environment was professional, the pay was at market rates, and that she'd be happy to work for him again. But the letter is unsigned. The last letter is from someone who went to college with Mr. Gerald 30 years ago. Of the 8 letters, only 2 are signed, and none of the letters that I could see describes any form of rehabilitation or addresses, how he's responded to this board's revocation decision and dealt with his prior misconduct. Mr. Gerald submitted documentation of some community volunteer work showing that he has served on a number of occasions as a bell ringer for the Salvation Army outside a grocery store in Palm Springs. That concludes my summary of the case. Mr. Gerald has the burden of proof, and once his and his counsel's presentation is done, I'll have questions for Mr. Gerald, Your Honor.
Thank you, Mr. Drakkar. Mr. Harris.
Thank you, Your Honor, members of the board. It's nice to be here today and see some familiar faces and some new faces. And we thank you for your time and your consideration of this petition by Mr. Gerald. There is no dispute with anything just said by Mr. Drakkar. The reality here is that Mr. Gerald has had to really reflect over the last several years on the conduct that led him to be sitting before you today. That reflection has led to humility and a broader understanding. Believe that through his testimony, you will hear of someone who has a completely different outlook on his actions and the case that he was presented with in 2023. You are aware through the materials submitted and from Mr. Drakkar that Mr. Gerald seemed to try to rationalize his behavior in 2023, not only to the board's Enforcement Advisory Committee, but at the administrative hearing. I think what you'll hear from Mr. Gerald is the idea that he got entrenched in trying to defend something that you couldn't defend. And sometimes life gets the better of us. We believe that the evidence will show that he has continually tried to better himself through his work as a CPA and his licensure in Florida, and is committed to practicing in the state of California pursuant to all of the laws and regulations that exist. You will hear in his testimony about the letters that have been submitted, the knowledge of the authors of those letters regarding his licensing status, and you will hear about the efforts he has made to be involved with his community. At the conclusion of this hearing, we would ask that your body agree to issue a restricted or probationary license to Mr. Gerald, where he can continue to demonstrate with whatever terms that this board may deem appropriate, that he can be a safe and competent practitioner in the state of California. And at this point, I do have questions for Mr. Gerald, if that's how you would like me to proceed, Your Honor.
Sure. Mr. Gerald, would you please raise your right hand, sir? Do you solemnly swear or affirm under penalty of perjury that the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Thank you, sir. Mr. Harris.
Thank you. Mr. Gerald, good morning. I want to talk to you a little bit about your background. Can you please tell the members of the board how old you are?
Yes, I'm 56 years old.
And can you please tell them your educational background?
I have a undergraduate degree from California State University, Fullerton, Bachelor's of Arts in Finance, and then I have an MBA from Regent University in Virginia. Cal State Fullerton, and then Regent University, Regent. Sorry.
When did you decide that you wanted to become a CPA?
After graduation from my MBA, I did some private industry, and then I went to work for a CPA firm in Orange County back in 1998. So that was about the time. If I wanted to move forward in this career, you really need a CPA certificate.
And what was your employment between that initial position and when you received your CPA certificate here in California?
I was enrolled agent. I started with the CTEC, California Tax Education Council in California, with that licensure. And then I became an enrolled agent. And then again, I followed the steps in the career. And then I became an enrolled agent. And then I wanted to become a CPA. So then I worked for a certified public accountant and obtained my Type G experience. The Type A in the application. Type A is for the application. There's like the Type A test, and then there's the Type A application. So when you apply, just to clarify, is when you apply for licensure, there's a Type A application. So it's a little confusing. So I'm requesting Type G, just a general request. But to answer your question, I became an enrolled agent, practiced as an enrolled agent.
And for how many years did you practice as an enrolled agent?
From, let's see here, I think 2006 to 2012, may even been before that.
Mr. Gerald, could you please pull the microphone just a little bit closer to you?
Sorry.
Thank you.
And during that period from 2006 to 2012, when you acted as an enrolled agent, were you ever subject to any type of investigation or disciplinary action?
Overall, no. I had one issue that I was fined by the IRS $1,000, which was in my original CPA application, because there's a gentleman in San Diego that he'd submitted way too many miles, and they felt that the miles were overstated, so they fined me $1,000. So that was the only issue, but the IRS cleared me of all that.
Understood. When did you decide that you wanted to obtain your attest experience?
Well, I've always wanted that. I've always wanted to be an attest CPA. I get referrals all the time, and I know how to do. I know how to do the work, but again, there's procedures on how to obtain that. But yeah, since I've obtained my licensure back in 2012 in California as a Type G general license, I've always wanted to be to do a test work.
In what year did you start obtaining your hours towards your attest work experience?
1998, when I worked for the firm in Newport. I mean, I have hours from there too. So, but yeah, back in 1998.
Okay. And when did you first apply for your attest license?
I believe it was 2021. That was within the state of California.
And why did you wait so long?
Well, I knew the state wasn't gonna. I mean, it's kind of like catching a falling knife. The state's not going to approve it because it was so far back. And you really have to have an attest CPA that wants to step up to the plate and really sponsor you and sign off on your hours. So, but I do have the hours, but again, you have to go through the correct procedures within the state of California. And if you don't do that, then you don't get the license. So, I hope that answers the question.
Do you have an understanding of the importance of obtaining your attest experience hours under the supervision of a licensed CPA?
Yes, I feel that it is a good system. And yes, you have to work under an attest CPA. The attest CPA has to sign off on it. And yes, it's a very strict. I call it the top rung in California of the CPA ladder. I mean, really, that is a CPA doing a test work. I mean, that's full on accounting services. You can sign off on a financial statement. So yes, I'm aware of that.
And it's been loosely discussed, but why were you going to have issues certifying your experience for attest hours?
Yeah, because one gentleman's deceased in the firm in Newport. I doubt that they'd want to sign for that. So I was competition. I'd always bring in new clients, even in Newport. They would call me instead of the partners. So, yeah, that's my answer.
And as part of your disciplinary history, the revocation is based upon the fact that you used a fraudulent stamp of someone else's signature?
Yeah, it was to present my hours to the board for them to determine whether they wanted to accept those hours or not. So I submitted his. I mean, it's impossible to get a signature from a deceased person. It's just not possible. So to go about doing that it's obviously not appropriate. It's a moral failure on my part to go down that path. But within my career of all my CPA experience, this is the only issue I've had. And I just want to say one thing is that, again, it's the golden ticket in California to get the attest, because first of all, you're going to get a lot more work and you're going to get a ton of billings. I mean, it's just the way it is. And it really is, in my opinion, it is a CPA if you can do a test work. You don't have to do it, but that is the top rung and the golden ticket from Willy Wonka, if I can use that. Only a few people get that level. And the way that I went about doing it is unprofessional, unethical, and can't do it. I mean, I can't self-certify.
Let's talk a little bit about that. You heard that you recall participating in an investigative interview with the Enforcement Advisory Committee of this board.
Yes.
And at that Enforcement Advisory Committee, did you try to justify your actions to the committee?
Yes.
And you then had an administrative hearing before an administrative law judge. Do you recall that proceeding?
Yes, a lady in San Diego.
And in reading the decision of this board, which was drafted by that administrative law judge, it's clear that you failed to take responsibility for your conduct.
Yes.
Do you have a sense as to why, during those two proceedings, when the board gave you an opportunity to explain your behavior, that you were unable to take responsibility for that conduct?
Well, to be real upfront with you, I was considering a different profession, because this is like I was seriously considering moving into a different profession and just leaving the CPA profession altogether. Because it's like, well, why do I do all this work and no one wants to support me? I know I sound like a victim, but that was my mindset. So I said, I'm presenting my hours, and if the board wants to accept those, that's great. If not, then, but the problem is I like being a CPA. So I would like to continue to have my license in California, if possible. And but to answer your question is that was, I wanted to present my hours, and if my thoughts were, it's like, well, if I don't get the top rung, I'll go into another profession. So but I'm really good at what I do, and I get a lot of referrals, and so that's why I like to stay in this profession as a type G within the state of California, general license.
And do you have an understanding as to why it would be fraudulent to submit certification hours using a stamp representing someone other than yourself?
Yeah, you can't do that. I mean, it's you have to give the form, the attest form, to the attest CPA. The attest CPA needs to complete it. They need to sign it, and then it gets submitted to the board. I really shouldn't have my fingerprints on it at all. It's really a separation of duties. Is that you do the work as a staff person, and then the attest CPA chooses whether they want to certify that or not and sign off on it, because they're attesting, and I know I'm just saying this to myself also, they're attesting to the work that I've done. So that's the way our procedures work within the state of California.
Do you have a sense as to why your perspective has changed in the years since your revocation?
Yeah, I mean, you can't do that. I can't sign someone else's name, especially if they're deceased. That's not appropriate. It's definitely unethical and behavior. So it's the form should have never been submitted. I can't submit the form. The CPA should have submitted the form.
How would you describe the sanctity of your signature and the signature of your other CPA members here when they sign forms like tax returns?
Oh yeah, no, it's a big deal. It's signed under penalty of perjury, and you have to make sure that what you're saying on that form matches. I mean, I've dealt with people that do 1031 exchanges, and they want me to sign a form that they're not showing that the 1031 exchange is moved to another state. Well, California is still entitled to the money. So it's a pretty big deal. Our signatures carry a lot of weight. If it's obviously a firm signature, it carries a lot of weight also. So I did undermine that on the attest side. And again, I know it's still a moral failure at the top level. But yeah, it's important. Our signatures are very important.
Do you have an understanding of why the board may question your credibility?
Oh yeah, absolutely. Because I submitted a form that had a fraudulent signature. And that obviously undermines the person's credibility. So yes.
And in addition to undermining that person's credibility, do you also see how it might jeopardize or undermine the licensing process itself?
Yeah, because then, you got to, again, it gets back to someone else has to attest to my work. And I'm attesting for myself for my hours and with someone else's signature. And that's not appropriate.
As you sit here today, do you deflect responsibility for any of your conduct?
No, not at all. I mean, I take responsibility for my actions. So the form should not have been submitted. It has to be submitted by an attest CPA, not me.
You're also licensed in the state of Florida?
Yes.
And since the revocation of your license, have you resided and practiced accountancy in the state of Florida?
Yes, my business is located within the state of Florida. All my clients are aware of that. All the tax returns reflect St. Petersburg, Florida. My business is in Florida. My business license, my professional liability insurance. I don't meet with anybody within the state of California. I don't do any advertising. Everybody knows that I'm in Florida, under Florida licensure. All my clients.
And in the presentation by Mr. Dakar, we heard about some of your letters of reference referring to ongoing accountancy work. And in the memorandum that was provided to this very board, there's discussion about your ability to provide accountancy work, tax preparation to California individuals and businesses. Are you aware of that particular issue, just the issue?
Yes, and I was under the impression, and I understand, of mobility. However, the mobility is terminated when there's a revocation, after you advised me of that. So I was under the impression that it was more like a C-Tech. So if I'm signing in Florida for California clients, then it would be like the same as a C-Tech, California tax, just a tax preparer. I'm signing as a tax preparer. So that was the position that I was taking. But after speaking with my attorney, I'm aware that I cannot sign for California clients since I have a revoked license in the state of California.
Did you intend to violate any of the rules or regulations about practice privileges here in the state?
No, none whatsoever.
And do you now have an understanding of what you would have to do in order to provide services to the state of California?
Yes, that's, again, I'd like to respectfully request that I come back under the board's authority, even if it's probation or you want me to take a test or what have you, because now I'm back under your authority for signing any type of tax return within California. Again, just type G, no attest, no, not signing financial statement or attest financial statements. So that is the goal or the request, if you will, so that I can come back under the board's authority and sign California tax returns, provide quality type G CPA services. And so that is the goal.
Since the revocation of your California license, was the Accountancy Board of Florida notified of the disciplinary action?
Yes, in writing, and I made it aware to them, and the board said you should seek reinstatement. They said since it's an attest issue, we're not going to get involved with it. However, best practices, you should have your license reinstated within the state of California. And then it also creates a mobility. It reinstates the mobility provision because now I have the license isn't revoked, so it creates mobility in California, and I would still be under the board's supervision for those returns. So that's it creates accountability back in California.
You have submitted close to 170 hours of continuing education. What have you learned from the various types of education that you've taken?
Yeah, I mean, I continue to grow in my practice. I've taken ethics classes, and I've also taken the tax. So I stay up to date on all the tax rules, both federal and throughout the United States. And my goal is to provide quality CPA services. Again, my clients, this is more of a family affair, if you will. And I know it's a big deal because it's signing for an attest. But my clients are really pleased with my work, and I've had no issues with either the IRS or any other state board. It's really just this attest issue. So yeah, so my goal is to continue with the continuing education, to continue to build my professional practice, and to do really good work for clients throughout the United States.
In support of your petition, you submitted a number of letters of reference. Do you recall that?
Yes.
And are the letters that are in the packet, are they true and correct copies of letters provided by individuals that you know?
Yes, and they're not physically signed, but they were emailed to me directly from the clients. And in today's day and age, it's not always easy to get a ink signature. So, but those are solid letters of reference, and every one of them said, yes, we would like you to be back license within the state of California. We appreciate your work. You've done great work for us over the years, and they feel I'd be an asset to the state of California, which I mean, I'm a Californian. I was born and raised here. So, yeah, they all are aware of, and those are solid letters of recommendation.
To be clear, for the record, are they aware of the purpose of writing the letters in your seeking to be reinstated?
Yes, they are aware that I have a revoked license within the state of California, that I cannot have my CPA business within the state of California. And they understand that, I mean, it's on all my forms. Everything says Florida. So they know I'm in the state of Florida business-wise. But the references, they want me back in the state of California. Best practices, not only best practices, but one of my clients paid for my legal fees that lives in the state of California. He's an elderly gentleman, about 80. And he says, yeah, he goes, you've helped me like a lot. And he says, I want to do whatever you can to get your license back within. That's Peter Cousins. He's and he said, I'd like you to have your license back in the state of California. You let me know what I can do to help. I said, well, I got to hire a good attorney, and I got to go before the board and present a case that shows that I'm capable, reliable, and should be licensed within the state of California. He says, well, I want to help you. So he says, I'll pay for your legal fees. He lives in Laguna Niguel, California.
There's reference in your petition packet of some of the charity work and religious activities that you partake in. Can you briefly tell the board about those?
Yeah, every Saturday I watch Shadow Mountain Church in San Diego with Dr. David Jeremiah from 5 to 6. And that's kind of my religious background. And then I also did the Salvation Army this last year. Only raised about 400 and some odd dollars for 20 hours. Probably would have been better just to give them a donation, but it was good. It was in Palm Springs. I was a bell ringer with the Salvation Army for about 20 hours, and the people really appreciated it. Palm Springs is an interesting area. It's kind of old fashioned. So when they see a bell ringer, it brings back memories of when they were a kid and they used to go to the grocery store with their mom and everything. So it's kind of, so yeah, that was really quite enjoyable this last Christmas.
And turning back to your license.
Yeah.
Why do you want a license in California?
Yeah, because I'm a Californian. I mean, I have, and I want to continue to help build our state. And we're a successful state. And whether people say they're leaving or not, we're still going to make money in this state. I mean, it's a good state. And I have clients that are requesting my help. They're requesting the help from me. And I want to be able to step up to the plate and provide CPA type G. Again, I want to make it clear, even in the letters, type A is like, there's two definitions. Type A test, and then type A application. Remember when you first apply, the application is, so I was kind of a little confused. I'm not submitting another application. I just would like to have my type G license reinstated within the state of California.
If you're relicensed, what steps are you willing to take to ensure that the type of conduct that led to your revocation never occurs again?
Yeah, probation would be good if someone wants to review my work. Continue to take solid CPA. I'm probably going to join Cal CPA right now. I'm in the FICPA. And just kind of to give you a little bit of a background of how this kind of, like when you say you get hit with a ton of bricks, is that, okay, so I lost my California license. Okay. Then I lost my enrolled agent license. I just want to give you the picture behind it. Then the AICPA said, well, we're revoking your membership. And I like the AICPA because that's where I get a lot of my CPE. So it kind of all came to roost that, well, I'm like destroying my career. This is really dumb. I mean, all this time that I've spent in my career. So that's why I'm trying to get everything back to the type G, become a member back with the AICPA, and then sign up with the Cal CPA. And that would be where I'd take my CP, because AICPA has really good continuing education.
Is there anything else you would like to tell the board to provide them confidence that it would be safe and not against the public's interest to reissue you your license?
Yeah, again, as the type G, I've had no issues. State of California, Florida, anywhere. But what I did to obtain the top rung, again, CTEC, enrolled agent, CPA type G in California, CPA in Florida, which is a one-tier system. So it's real big on peer review. So everybody gets peer review. And then I was reaching for the top rung in California and I fell off the ladder. So, so that's the way it is. And I still get other firms that reach out to me that want me to work for them as tax managers to do, but I said, well, I don't have a license in California. So, and again, but I'd be back under the California board's authority. And obviously you could discipline me again, even more severely if necessary. But yeah, CPE and continuing to do, joining the professional organizations that create the standards that we live by. I mean, AICPA Code of Professional Conduct. On my engagement letters, I say all actions taken by Sean M. Gerald CPA will be in accordance with the AICPA Code of Professional Conduct and IRS, United States Treasury Circular 230. So those are my standards, our standards that we live by. I mean, I fell off the ladder. Just being upfront with you, as I was going for the top rung, the way that I did it was incorrect. And I would like to please be considered for type G if it's probation, or if you want to take, maybe take an exam or what have you, to please consider that.
Your Honor, I have no further questions for Mr. Gerald.
Thank you. Mr. Dakar?
Thank you. Mr. Gerald, tell us about your current accounting practice. You've got the Florida license. Do you have a firm?
Yes, I have a small practice in St. Petersburg, Florida, which is outside of Tampa.
Do you reside in Florida, California, or both?
My business resides in California. I reside in California because my family lives here. I have a family. My parents are in Fullerton, and my brother and sister-in-law are in Lake Forest.
Turning to your forged certificate of experience, when you submitted that to the CBA back in 2022, did you think that was unethical then, or have you just come around to understanding later after you got revoked that it was unethical?
It's not right. I mean, you can't sign for someone that's deceased. The person can't speak for themselves. So, yeah, I mean, when I signed it, yeah, there's a question of whether it would be ethical or not at the time also, but even more so now. I mean, the penalties kind of wake me up. Now, am I doing this? I mean, obviously I want to be a CPA within the state of California under type G, but yeah, I can't do it. It's unethical. I can't provide test services. I can't sign someone else's name. That's fraudulent.
Was it a situation of knowing deep down that it was unethical to submit the forged certificate, but you were downplaying that because you really wanted to get that attest?
Yeah, exactly. I mean, yes, exactly.
If you were to be reinstated with the G license, would you seek opportunities to do attest work under the supervision of a CPA with the attest designation and to earn in the future that attest license?
Yes, and for that to be submitted by that attest CPA and I don't sign it, here's the form, you fill it out, you sign it, and you mail it in. So, or submit it electronically. So I'm not involved with it at all.
What have you done, if anything, to reform yourself, to improve your ethics and your professional common sense since your California license was revoked?
Yes, I've taken ethics classes with the IRS via Circular 230. And I've also taken the CPE. And I feel that my church service brings me around also. I attend church every Saturday evening. I feel that's a moral code and a moral check also.
Why should this board believe that your ethics and morals have reformed since 2023 when you testified at that hearing?
Yeah, again, I think it's a continuation. I've had no issues with my morals or anything like that. However, to obtain a top CPA in California, it was a lack of judgment. It was a moral failure. So to be upfront with you, I got my hand stuck in the cookie jar. I mean, that's just the way it is. I mean, if I painted it differently, then that wouldn't be telling the truth. But yeah, I've still had no issues with any of my clients. None of them have had any problems. There's no IRS or state issues. It's really like this is a family affair that I'm trying to get to the top level within the state of California, but can't do it. And the way that I tried to do that was unethical and fraudulent.
You testified about previously being a C-Tech. When did that registration expire? How did that end?
Okay, so I think it was back in 2000. I just was getting so many referrals, even at the firm that I was at, or people were saying, hey, you want to do my taxes? So I got the C-Tech. And then I decided to go on my own, became a certified QuickBooks Pro advisor, started building my clients. So then I go, I'm going to be an enrolled agent. And that's after I had the issues with Sammy Shabbatai. And then I said, well, I'm just going to become an enrolled agent. And then I did representation also, helped a gentleman up in West Hollywood that had HIV and no one wanted to help him. I helped him and we got a settlement with the IRS and he's back in the system paying federal and California taxes. He makes a lot of money. And so I got my enrolled agent license. And then the next step was the CPA, and where I fell is at the CPA test. So back in 2000, I would say is when I had my CTEC, and it is expired when I got my enrolled agent license, probably 2000, I think 6 or 8.
Since revocation of your California CPA certificate in 2023, have you been holding yourself out as a CPA to California residents?
No, I've done no advertising. I've said I'm in Florida. All my letterheads, everything says St. Petersburg, Florida. The tax return says Florida. My professional liability insurance, my P10 with the IRS, which is still active. That is everything is in Florida. So my business is in Florida. If someone were to call me, they would say you're in Florida. And I don't say, hey, I'm in California, let's go have a coffee. I don't do that.
All right, and I just want to confirm, you've been preparing taxes and tax returns for California residents and businesses, but doing that through your Florida CPA license?
Yes. However, and again, I want to bring full close. I want you guys to see the complete picture. After talking with my attorney, there is a carve out. Mobility ceases when there's a revocation in that state. So yes, I have been signing for California clients.
What proportion of your total business has been for those California tax funds?
Probably about 40%.
Okay. So now that you know that the California law prohibits you from practicing in this state under your Florida license without requesting and receiving permission from the board, if your petition is denied,
yes,
what do you plan to do? Are you going to keep doing taxes for those clients?
No, I've already reached out to, I can't think of the gentleman's name, at Accounting Practice Sales, Jake Hodgkins. I had so many clients that I couldn't service them. My business model is not to get big. It's I want to enjoy my life. So I have my own clients and do my own thing on my personal time. So I don't want to hire 10 people, but the people that I take care of it's top notch. They're taken care of. So I had sold some clients, and if need be, I would sell my clients to a reputable CPA firm within the state of California through Accounting Practice Sales. So I'm willing to completely withdraw, disengage from the state of California.
All right. Thank you, Mr. Gerald. Your Honor, those are all the questions I have.
Thank you, Mr. Dakar. We'll now open it up to questions from the board, starting with Ms. Dong.
Thank you for coming in today. So my first question relates to your work in California. When your license was revoked 3 years ago, did you inform your clients that your license was revoked?
Well, I informed them through changing the location to Florida. So whether it was a direct yes, no. I didn't send out a letter saying that it was revoked, but I immediately moved everything from Laguna Hills, California to St. Petersburg, Florida, which is outside of Tampa. And everybody knew that I had moved my office under my Florida CPA license. So I can't say I formally sent out a letter, I'm revoked. I did not do that.
Mm-hmm. So you did not inform your clients that your license was revoked, but you continue to prepare tax returns for California residents. Were you at that point still registered with CTEC?
I was not registered. I cannot be registered with CTEC. If I had looked into it, I did look into see if I could get registered with CTEC. So I was saying, well, let's see here. I really like to have a license. And it looked like I couldn't apply for CTEC, no. But I was, again, under the impression, I want to go full circle, that mobility still applied, but it does not. It gets carved out if you have a revocation in the state of California.
So your license was revoked, you were not a CTEC, and by your own admission, you also were not an enrolled agent when you prepared these tax returns for California residents.
Oh, the enrolled agent license was revoked also. I mean, that was the IRS was aware of it, and I had an attorney from the IRS call me and said, well, you got to get this straightened out. Mm-hmm. We have to put you on, we have to revoke your enrolled agent license until you get this straightened out. So mm-hmm. No, the only license I had was in the state of Florida, under the Florida board.
And you were preparing these income tax returns for a fee?
Yes.
Okay. All right. That's all my questions. Thank you.
Mr. Lynn? Ms. Lana?
No questions.
Mr. Aguilar?
Thank you, Mr. Gerald. I have a couple of questions. How is it that you ended your work or practice ended up in Florida? You're born and raised here in California. What's the connection that got you there?
Yeah, I moved to the state of Florida specifically for a test. I mean, I said, well, I mean, if the California doesn't want to, I'm not trying to be, but I want to give you the full picture. If California doesn't want to give me my license, I'm moving to Florida. Florida says, well, yeah, come on over. We'll give you your test license. And I bid on Habitat for Humanity in Florida, some really solid nonprofits that would have liked me to do their work. But my family's in California, so Lake Forest, Fullerton. But again, the way that I went about doing the test, because it's different. I mean, California has their own standards, and I went about it the incorrect way. So, but that was the impetus to move to Florida, was because of the test licensure. So it created a roadblock, in my opinion, in my career. So, I mean, if California, I mean, don't take it, but this was my thinking. If California doesn't want to help me, Florida will. So then they were saying, yeah, come on out, we'll license you. And I have my complete license in Florida.
Do you have a residence in Florida?
No, I do not.
An office in Florida?
Yes.
And
Yeah, office in Florida, yes.
can you describe that office?
Yeah, it's like a Regis. It's a mobile type of office. So it's almost like a virtual office. So, I mean, I can meet with clients if I need to there, but it's basically, it's not RTO, but when you're working remotely. So it's basically, I'm basically working remotely from California to Florida. But no one, there's been no advertisements. I seriously have met with no one within the state of California. Like, let's go meet. I'm in Florida.
What percentage of your client base has a Florida address?
Probably about maybe 30 to 40%, because I have clients throughout like Washington State. And as you grow, you just get people that move. And so, yeah, I mean, I have about 40% in California, about 30 to 40% in California, and the rest are scattered. So,
And the reason why I'm asking these questions is form versus substance. So the form of your business is a Florida business, but you live and reside here, born and raised, have say 30% California clients. It seems like the substance of your business is a California practice. What would you say to my perception?
well, my business is located in, I mean, if I'm working remotely and I live in North Dakota and I'm working for people in California, and my business, or let's say I'm in California working for people in North Dakota, and the office is in North Dakota, I'm remote. So I could work, either it's in California, I could do my work in Hawaii, I could do my work anywhere within the continental in the United States, so that 7216 isn't violated where the forms go overseas or what have you. So all my work is completed within in the United States. So mobility, or not mobility, but working remotely would allow me to have an office in Florida and a license within the state of Florida.
My last question is, I understand that not all the fees have been paid. Is that right?
No, yeah, no, sir, they have not.
And why not? They're not due yet, or?
I don't have the money right now, but I did submit a letter in the package that 100% of the fee would be paid, all of it. Yeah, everybody needs to be paid for their time. I mean, if I don't, I'm not looking for a reduction of fees or anything like that.
Ms. Batchelor?
Thank you for being here today. I just have a couple of questions for you. And I wanted to speak with you about CTEC. And
Yes.
because you said your California base of clients is about 40%, you stated that you were not able to obtain a CTEC license. Did you ask them and they gave you a reason why you could not obtain another CTEC license?
No, but I did some research on it. Actually, I did some research on it, and I think it was the hours that I needed to take within California. So I think I don't remember whether I can obtain a CTEC right now with a revocated CPA license, because I did research that, because that was something I did consider. I said, well, maybe I can get a CTEC license to sign tax returns. And there was some type of roadblock that it wouldn't work, but I would need to check into that.
Yes, that's something that would have been very helpful.
Yes, no, I agree. Yeah.
Okay. And the other question I had is in terms of Florida, you discussed this issue with their board, and Florida, you stated this, Florida said it's an attest issue. That's why they're keeping your license as a test, and they did not revoke you. Because normally what happens is if you're revoked from one state, it has impacts on another state as well. So do you feel that this is a test situation, or it's more of an ethical situation?
Well, it's both. In other words, it's a test because that's the goal that I'm trying to reach, but it's also very ethical and fraudulent the way I went about it in California. So it was it's a fraudulent act within the state of California because the form is not valid. It's not it has to be rejected.
Okay. All right. Well, that's all I have. Thank you.
Mr. Rapel?
No questions.
Ms. Du?
Could you clarify? Oh, thank you for being here again. Could you clarify to me? Ms. Dong was asking you if you have done, since your license has been revoked, tax return for California clients. When was the last time you done a tax return where you sign for a client that is reside in California?
Probably about maybe 2 months ago. That's when I started discussing it with Mr. Harris regarding the carve out. But again, I am yeah, I was going to say if like I said, if California does not want me preparing tax returns in the state of California, I'll accept that, and I'm willing to sell my clients, my California clients. I've already done research on that with accounting practice sales. To a nut, because I don't want to just say, hey, have a good one. I want them to get. I take care of my accounts, so we want to. Hey, this is a good firm. These guys will take care of you. And so, yeah.
So you mentioned that you became aware 2 months ago that you were not
That I can't sign for California.
right.
Based on my talking with my, that there's no mobility. Mobility has, and via this hearing, that's when the letter was sent to me, and then my attorney said, yeah, there's that carve out. You can't sign tax returns for California taxpayers.
Okay. And then before that, your reading of the decision, you thought that you still were able to sign tax returns for California?
Yes, for California under my Florida CPA license,
under.
similar to, yeah, I still have a license. It's not like I'm unlicensed activity. However, it could be because I'm not licensed within the state of California. So, because it's revoked. But again, my position was a tax preparer, basically going all the way back to CTEC, back in when I first started signing tax returns.
But you mentioned that your CTAX license is not current and the last expired in 2006, right?
Yeah, so basically what I did is I got my CTEC, and then when I got my enrolled agent license, I don't need the CTEC license. So it's just more paperwork. So the CTEC, now enrolled agent, and then I became a CPA. So I had my CPA, enrolled agent, and then I got my Florida license. So all three were going fine, but this is a bad idea. So submitting the form fraudulently basically put me all the way back down to, I was thinking CTEC. I mean, I did research CTEC, and there was an issue that came up though. I remember there was, I would have to look into it because I did look to see, hey, I should really probably go back to CTEC for California. So it's not like forget California. No, I was looking to make sure. I want to be in compliance. I'm not looking to skirt the laws or the rules.
That's all I have to.
Thank you. Ms. Corrigan?
No questions. Thank you.
Ms. Zielinski?
Thank you for being here. You mentioned with Ms. Dong's question that you didn't provide formal notice to your clients, but changed to your Florida address. You also mentioned during your testimony earlier that Peter Cousins, one of your clients who also provided a support statement, is paying for your legal fees. Is Mr. Cousins aware of your license revocation in California?
Yes.
Okay.
Yes.
And when did you tell him?
No, he was aware basically what happens was when I lost my license in California, I don't have a license in California anymore. So I sent out a letter to all my clients that every year I send out a client memorandum with my fee schedule so that there's no surprises. I tell them what my billings are. I tell them that I'm under the AIC Code of Professional Conduct. So if any client ever comes back to me and says, hey, why do I have this bill for this amount? Because we're CPAs, we're not cheap. So I can say, well, I sent out my fee schedule. So on that, it showed my Florida address, and I usually staple my business card to it, which has all my Florida information. And when I send out my tax organizers, that has Florida on it. So is there an indirect notification? Maybe, but not a formal, I'm revoked in California. So there was never a formal letter sent out.
So did you specifically tell Mr. Cousins that your California license was revoked?
Yes.
Okay. When did you tell him, and in what manner did you tell him?
Yeah, it was a while back because he'd asked me, he goes, did you move to Florida again? I said, no, I'm having issues with my California license and I can't have I don't have a CPA license in California anymore. So whether I said it was revoked, but I did tell him that I don't have my California CPA license anymore.
Does he have an understanding of what his payment for legal fees are?
Oh yeah. No, he wanted me to become into compliance, best practices, and I'm going to 1099. He's going to 1099 me for. It's going to be in lieu of, so he's going to pay, and it's for tax and accounting work. So yes, he's aware of what he's paying for. He said, "Yeah, I want to help you get your license reinstated within the state of California."
Okay.
Yeah.
And he's based in California.
Yeah, Laguna Niguel.
And in lieu for tax.
Yeah, he's in his early 80s, cancer survivor, makes really good money, and very kind man. And I don't know if I should share this or not, but his sons, he has twins, and they were the actors in the movie Twins with Arnold Schwarzenegger. So those were his kids, and he's a very nice man, but he said, you really need best practices, and you need to get your license reinstated in California.
How many hours of CE is required in Florida?
80, 40 per year.
Okay.
So it's the same as pretty much everything's the same, except Florida has a tier 1 system with peer review. You have to be registered for peer review for a test. And so they kind of take that approach. California, which I don't disagree with, is more of a hands-on mentorship, which is it's not bad because you learn a lot. I mean, you really, really do learn a lot by doing the field work and having the partners, all your review notes. So it's not a bad system. I'm not knocking our system. It's a difficult one.
Okay. Thank you. No further questions.
Ms. Thompson?
What year did you redomicile your business to Florida?
Originally, it was, I think, 2018.
Okay. And how is your business legally formed? Is it a sole proprietor?
Sole proprietor. So I registered with the Florida Secretary of State. Then I have my business license and my profession. I do have professional liability insurance. So is California protected? Indirect, but would they have to raise the issues in Florida? Probably. So, but I do have professional liability since 2000, since I received my enrolled agent license.
Right. And as a sole proprietor, the domicile tends to follow the seat of management, where operational majority is or where control is presumed. How much time are you spending in Florida?
Well, business-wise, 100%. I mean, I'm working remote.
How much physical time are you spending in Florida?
Physical time, not very much because my family's out here. So I'd say limited with regard to physical presence there.
Do you have any employees?
No employees.
Okay. So 100% of the work for the business is occurring physically in the state of California.
Well, Remotely, yes.
Well,
I mean, if I worked in Arizona or Nevada, it would still, and the business was in California, I'd be a Nevada or Arizona.
You would be in Nevada or Arizona, but you're probably familiar, California is an economic nexus standard, which doesn't, sorry, it's an economic nexus standard. It's a business concept. Sorry. As a sole proprietor, your seat of business in California will follow the location of management or the books and records, which it sounds like is going to be out of California. I respect that legally the domicile is in Florida.
Yeah, I file a tax return for the state of California and pay my taxes with, I claim my 1040 and Schedule C. It says Florida, but I do pick up the income within the state of California
Right.
and would pay, because I'm not gonna, that's a tax strategy that, oh, I'm in Nevada, but my business is in California and I don't have to pay. No. That used to be on the radio all the time, but yes, I file my federal and California tax return, no filing requirement in Florida because there's no state taxes.
Okay. And then just to piggyback off of the question Mr. Aguilera had, what is your specific timeline or plans on repaying the, I think it was about a $13,000 assessment?
Yeah, during tax season, I plan on paying more because as I make more, I pay the board more. I mean, things have gotten expensive, so especially within the state of California. So as I receive monies, I pay the state. I would say that if I was, this is just it's up to the board to decide, but if I were to be put on probation, then I would have everything paid, obviously, by the time that probation ended.
Why do you think the board should consider your petition before completion of repayment?
I don't have the money. I mean, I don't want to sound like a victim, but a payment plan would be appreciated. That's all. That's really all I can say.
I guess last question. Why should the board believe that your judgment today is different than your judgment in 2021 when the application was completed with a falsified signature?
Really, my moral standards haven't changed. I haven't changed. I've come to the realization that that is a fraudulent act. I cannot submit that form within the state of California, period. It has to go through an attest CPA. That's the California board standards. The California board says, look, you want to be an attest CPA? You need the hours. An attest CPA needs to fill it out. You got to work for that person. And that person, they can give it to you and you mail it in or submit it, but then it goes to, so really the issue is I committed a fraudulent act within the state of California for that form, and the board took appropriate action. Have I changed my morals? It was more of a reaching for something that in a way that I shouldn't have. So it's a realization that that's a fraudulent act. I can't do that. And especially even talking to my attorneys, no, you should have never submitted that form. I mean, that was the advice from Mr. Harris, because you should have never even submitted it. Forget about it. So that was, which I felt was good advice.
No additional questions.
Ms. Hines?
Yes, thank you for coming in today. I just have a couple of questions about your CE courses.
Yes.
Which of your CE courses addressed issues regarding the credibility of documents or about documentation standards?
Yeah, internal controls. I believe I took a couple classes on internal controls and the ethics courses. The bottom line is our signature means a lot. Okay, so all my CPE just continues that our license is really well respected within the community. I mean, if you say you're CPA, people you usually have a good opinion of a certified public accountant, and just the title carries quite a bit of weight. So I would say the ethics classes, some of the document management classes that I took with the CE would help with regard to that. But I would say even more so would be more on the, I know this is kind of personal, but maybe on the religious side is you got to do things the way that the board wants to have, wherever you are under their authority. So.
Thank you. And another question, do you have a business license in California?
I do not know.
Okay, all right.
So basically and I want you to be aware, my position is I'm working remotely. I am not in California. I do no advertising. My everything says Florida. And when people call me, they think it's Eastern time. So it's even my CPE, my email is set up for Eastern time. I'm not trying to like, oh, I got a phone number in California. Let's go. No. I'm under the authority of California when I have my license, and if I'm located here, and yes, California clients, I would need to be under the authority of the California board. So that's why I want to, if possible, get back under the board's authority, pay my fine, and come back into compliance with the type G. That's my goal, if possible.
But you're working remotely in Orange County from a location in Orange County.
My house, Riverside.
Okay, Riverside County. And you have no business license to conduct business out of that location?
It's county, so there's no
county.
County of
business.
Riverside is usually county, city. If I was in a city, I would need a business license.
Oh, you're an unincorporated Riverside
Yeah, I have a
County.
nice little house out there, so that's it's a nice little area, so it's affordable.
Okay, all right. Okay.
So thank you.
Thank you. No further questions.
Follow up, Mr. Dakar?
No, Your Honor, nothing.
Mr. Harris, anything further?
No, Your Honor, thank you.
All right, Mr. Harris, any further witnesses or evidence?
No, Your Honor.
All right.
Oh, no, Your Honor.
Mr. Dakar, I will turn to you first for closing remarks.
Thank you, Your Honor. The petitioner, Mr. Gerald, has the burden to demonstrate by clear and convincing evidence that he is rehabilitated and that he no longer presents a threat to public protection. He now concedes that it was wrong to submit a forged certificate of test experience. He seems to understand why that was wrong. His petition, however, reads as if that belated concession is all that he should need to present to this board before he is reinstated. The record raises concerns about his continuous violation since he's been revoked doing tax returns for California residents. And the people are concerned that his showing of rehabilitation falls short. But with that said, I think you all now have the information that you need to make a reasoned and informed decision on this petition. Thank you.
Thank you, Mr. Dakar. Mr. Harris.
Thank you, Your Honor. Again, thank you, members of the board. I represented at the start of this proceeding that you would hear a different take that Mr. Gerald has of what occurred than what he presented to you a few years ago. He clearly got entrenched in wanting to grab what he called the golden ticket and lost track of the moral fiber that he believes he still has and continues to strive for, even through his religious activities, as he's discussed. He's also come before you very honest and open about his misunderstanding of the mobility provision. And I am sure you're all aware that in general, when there is not a revoked license in California, someone in Florida could otherwise practice through general mobility without any type of approvals. He made the poor assumption, without the advice of counsel, that that was okay. It does not excuse behavior, but it was not an intentional violation or to thwart your authorities. In terms of cost recovery, the order itself provides for costs to be paid prior to reinstatement or pursuant to another order of the board. There was no direct order to pay the costs that has been failed to be met. Mr. Gerald has candidly testified to his economic limitations and his efforts to make initial payments and his desire to continue to make those payments in the event that you do reinstate his license. We would hope that that would not be a condition that would be the basis for any type of denial of this petition application. Under the California Code of Regulations, Title 16, Section 99.1, this board has set forth many criterion of rehabilitation, of which you are likely aware. A brief recounting of those goes as follows. Prior to the revocation of Mr. Gerald's license in 2023, Mr. Gerald had no prior disciplinary history with this board, any other licensing board, or any type of other agency. He has no criminal background. He has no client-related issues. As the evidence has shown, he's never had a malpractice claim with insurance that he's had in place since he was an enrolled agent or CTEC. The evidence also shows that he has the support of multiple witnesses who have worked with him throughout his career and who support his bid for relicensure in California. And according to his own testimony, those representations by those who've authored the letters are true and correct, that they were provided electronically, and that they were done so with knowledge that they were supporting this petition proceeding. Further, we can look at the level of change of perspective and remorse. And if anything, that should be the paramount question here today, because your prior order in 2023 specifically questioned whether or not Mr. Gerald had the requisite understanding and taking of responsibility for his conduct, which he failed to demonstrate then. But again, he's come before you today with a change of perspective, an understanding where he's not entrenched in trying to just get something completed, where he's no longer the victim, but rather where he is someone who is trying to demonstrate that he understands the sanctity of his signature, the sanctity of your roles as CPA, and the fraudulent violation of those principles when he presented his attest form with a false stamped signature. As you're aware, this proceeding is not about relitigating the past. It provides the baseline from which we now look at the case going forward. He has already been punished and he has already been disciplined. And our question is whether clear and convincing evidence demonstrates that Mr. Gerald is rehabilitated and meets the criterion that have been outlined, knowing that there is no prior or subsequent disciplinary action, no criminal background, a change in perspective and remorse, ongoing continuing education, support from others, religious and community involvement, and the humility with which he has sat here today, even admitting that he misunderstood, the law and wants to correct everything so that he can come under your compliance. We were hopeful that you would consider issuing a probationary license with the terms and conditions which are necessary to monitor Mr. Gerald and to ensure that he has the requisite competency, character, and skill to service California consumers. Again, thank you for your time.
Thank you, Mr. Harris. Mr. Gerald, the board will now go into closed session for deliberations. You and Mr. Harris will be notified of the board's decision at a later date. With that, the matter is submitted for decision. The record is closed and we are off the record. Thank you, everyone.